Sir, go ahead. Good evening to all of you. I regret for the cancellation of the lecture yesterday because of some unforeseen events. Of course, the admin must have also told you about it. But please remember, in the sale of group, I think some other groups have also joined. And for them, I give an assurance that once we finish this topic, we will try to revise as far as possible. Of course, not a promise, but it's only an assurance. That's all. So go ahead.
You're on live.
Here, we were discussing about the biggest chapter in the Sale of Goods Act, and the entire Sale of Goods Act is dependent upon this chapter. They are called conditions and warranties. But before we go into it, we must know a term called caveat emptor. Caveat emptor means buyer beware. Buyer beware is Jago, I think they call it as Jago Grak or whatever it is. Here, we must make all inquiries possible. We must also try to find out whether the person selling is the real seller or whether the person who is selling it to you is the correct person authorized to sell it, and whether he has got authority from the real person when he acts as an agent. And all these things will have to be examined by you before you buy. And that is the reason, sir, when we go to a shop and we want to buy a television set, don't depend on online and all. You go to the spot, test the product, and also try to play and have a demo program also, so that you're satisfied about its performance. Here, please remember, every seller would try to sell a spurious. Sir, Mr. Subhash Agarwal, we'll meet on Saturday morning because we wanted to discuss that also with you, and we'll prepare a counter.
Are coming. I've sent my vehicle to take your palm.
Yes, sir. Sir, इनका वो काउंटर का बताइए. No, why don't you send someone tomorrow? You can hand it over so that we'll discuss it threadbare and then prepare the case, sir. And we have to file the counter in the injunction application also. We have not filed it, only the rejection we filed. He was making a big show about it. आइए उन्होंने जो इंजंक्शन के लिए डाला ना, आइए for injunction, not alienate the property. No question of that. Let us file the counter. You ask him how much show he made. That is
only rejection will be matter. Even talking.
So we were discussing about caveat emptor. So kindly come on Saturday. I'll keep myself free. We can, or we'll come there. We'll discuss it threadbare, and if possible, after discussion, we'll prepare the counter also. Let us not. And the judge also was irritated. He said, "You have taken 1.5 years to file a counter. How do you find fault with that?" Anyhow, first time I'm seeing that fellow in your case.
Have you gone through the counter, sir?
I didn't have time, sir. We'll discuss it threadbare and then go on. He has filed some document.
Second half, and we'll prepare the counter.
Not second half, somewhere around 12 o'clock, sir. Because other second half we got some other.
Yes, sir. Second half.
Somewhere around 1 o'clock.
That's what I'm thinking. One tarot actually.
You will be free after that.
It's like. So you go.
So just a minute. Excuse me. I was talking to some client. Okay, the first and foremost is, as far as Sale of Goods Act is concerned, you must know the doctrine of caveat emptor. Caveat emptor means buyer beware. Whenever, for example, when you try to go for an alliance, when you go for a bride, you try to make all inquiries about social, economic, financial, and society background also. And when you when you try to participate in races, also you study the various books and find out where the horse has run, what is the history of that horse, what is the weight of that horse, what is the height of that horse, who is the trainer, and who is the person who is going to, who is the jockey who is riding the horse. We don't bet on horses which are not going to win. In the same way, whenever we acquire property, be it movable or immobile property, You are supposed to find out who the actual owner is. The question is when you have to find out who the actual owner is, that is called caveat emptor. That means you must see whether he is going to sell it to you on bill or without a bill. Please remember now GST also has come. When you purchase some item, the GST also has to be paid by you, and whether GST has been levied at the correct rate or not, or whether the amount is shown in the bill or not. But sometimes what happens is people say, sir, whether you want the product with the bill or without the bill. But please remember, don't buy anything without a bill, because tomorrow if you want to claim the advantages of either the conditions or warranty, unless the bill is there, even you cannot go to the consumer court complaining of defective article. So KV tempter plays a very important part. When I come to Transfer of Property Act, I shall also discuss it in detail what repercussions it can have. Here, when we go to the subject in the proper perspective, we have the entire chapter on conditions and warranties covers the entire Sale of Goods Act. Here it is said where a seller of goods has obtained possession under a voidable contract under Section 19 or 19A of the Indian Contract Act, but the contract has not been rescinded at the time of sale, the buyer acquires good title to the goods provided he buys in good faith and without notice of the defective title. Here, the bona fide purchasers are protected, whereby it is said that once this is to be precise, that is where it says that the 19, what is 19, sir? 19 speaks about what is called fraud, etc., etc. When you say fraud or anything, then the question is when it's a voidable contract and the seller obtains goods and possession of the goods under a voidable contract under section 19 or 19A, but the contract has not been decided at the time of sale, the buyer acquires good title. See, when the seller sells the goods, he is bound to give you a good title, isn't it? Who will buy a product which is pledged, which is pawned, or which is subject to certain restrictions, or the seller was not bound to receive possession of those goods while buying that from a wholesaler? All these things you buy. You as a buyer, you buy it, think that all those things have been rescinded and all. There is an implied condition that the seller who is selling the product to you has got good title and that he can pass a good title to you. Then the question is, even assuming for a moment without admitting that the seller had a defective title, the buyer who comes into possession of the goods pays the price and also acts in good faith without notice of any defective title, the buyer gets a good title. Then the next one is where a person having title continues to be in possession of the goods or of the documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him by the documents or goods under any sale, pledge, or other disposal thereof to any person receiving the goods in good faith and without notice of the provisions of the shall have the same effect as if the person making the delivery or transfer was expressly authorized by the owner of the goods to make the same. Any person receiving the goods or document shall have the same effect as if the right does not exist. Here, sometimes you know what is a pledge, sir? When you have gone through the Contracts Act, when movable property is offered as security for the due repayment of a loan or to secure a pecuniary liability, then the person who is in possession of the goods is called the pani, and the person who pawns the goods or pledges those goods is called the pana. But suppose, let us say, the goods are pledged. The seller discloses all those things or he does not disclose.
Please, sir, slowly, sir.
Yes, sir. Here, what is meant by pledge? Pledge means in the Contracts Act, it is defined as where movable property is offered as security for the due repayment of a loan, that is money. Then it is called a pledge. And the person who deposits the movable property as a security is called the pawnor or the pledger, and the person to whom it is delivered is called the pani or is called the pledge, isn't it? And the transaction is called a pledge. Am I making myself clear to Mr. Sutikithan, sir? Here, pledges,
Yes, sir. Yes.
pledges where possession of movable property is handed over for the purpose of securing a loan. And the person who offers the security is called the pawnor.
Santhanam sir, can you please increase your voice, sir?
Yes, sir. The person who offers the property, mobile property as security is called the pawnor, and the person to whom the property is offered as security is called the pani and or the pledgee, and the transaction is called a pledge or it's called a pawn. Am I making myself clear to you, please? This is dealt with by section 169, 170, 171, 172 of the Contracts Act relating to contracts of pawn and pledge. Please remember please underline the word movable property. Please remember, no one would try to part with money unless he has a valuable security. And for that reason, most of us, whenever we are in financial difficulties, we pledge our jewels, we pawn our jewels, we go to a pawnbroker or we go to a bank and offer those goods as security until such time we repay the money, isn't it? That transaction is called a pledge or it's called a pawn. Am I making myself clear to you, please? Here, it is said where a person sold goods are within his possession and the documents of title to the goods for delivery or transfer by that person or by a merchant. Who is a mercantile agent, sir? Mercantile agent is a person whose business is to carry goods from one place to another on behalf of the other. Either you call it a lorry transport, or you call it as a railway, or you call it as some other private vehicle where his business is to transport goods or to carry goods from one place to another. That is called a mercantile agent. And when the goods are, when it is said, where a person has sold goods, continues in possession of the goods or of the documents of title to the goods, the delivery or transfer by that person or by a mercantile agent acting for him of the documents or goods under any sale, pledge, or other disposes them to any person receiving in good faith. So, a person who is actual possession of the goods, be it a seller, let us say, he hands over the goods to, or he is in possession of the documents of title also. What are the documents of title, sir? You can say the bills, so on and so forth. And when he hands over those documents of title or the goods itself to a mercantile agent for being transmitted to the buyer under a contract of sale, and the buyer receives possession of the goods, then even though it may be under pledge, it may be under pawn, it may be under any other thing, the person who accepts the goods accepts the documents of title, accepts it without any notice of the previous defective title, or acts in good faith, he acquires a better title than what his vendor himself had. Are you able to follow, please? See, when a seller is in possession of goods and of documents of title to the goods for delivery or transfer by that person or by a mercantile agent acting for him by the documents of title and any sale, pledge, or other disposition thereof any person receiving. So the question is, when a person authorized to sell is in possession of the goods, he is in possession of the documents of title, he has got ownership over it, or he has got title to it, or the documents of title are with him and is authorized to sell. For example, suppose you give the goods for being sold by an auctioneer. Who is an auctioneer, sir? A person who auctions the goods. On your, for example, most of the now second-hand cars also, you can hand it over to certain business people who can sell the car on your behalf. It can be done online, or it can be handed over. Possession can be handed over, and that person transfers that mobile property or the mobile property or goods along with the documents of title by himself or through a mercantile agent, or normally you call them as broker, to a person who is a purchaser, who pays the price, who acts in good faith, and he has no notice as to what is the title of the seller, then in that case, the purchaser gets good title irrespective of any defective title. Are you able to follow, please? Again, I repeat, where a seller is in possession of goods or is in possession of the documents of title relating to those goods, and that he wants to deliver it to another person who is a purchaser, then he hands over the goods and the documents of title to a mercantile agent who carries it along with him and sells it to a buyer who acts in good faith, pays the price, and he has no notice of the defective title. The buyer gets a better title, though the seller may not have title to the property. Are you able to understand, please? Provided the buyer acts in good faith bolo to, that is without any malice, without any malified intentions, he acquires the property pays the price, takes delivery of the documents, takes delivery of the goods. Then in case, even assuming the seller has no title or right to sell the property, the purchaser gets the title. Are you able to understand, please? Any doubts about it, Mr. Yes, please. Here again I repeat, where the seller comes into possession of the goods or the documents of title, which is ready to be transmitted to the buyer, he does it by himself or hands it over to a mercantile agent to be carried from one place to another. And the purchaser takes delivery of those goods, takes delivery of the documents of title, and also acts in good faith without any malicious intentions, and he has no notice of the defective title of the seller. The buyer gets a good title irrespective of the defective title of the seller. Is it clear to you, please? You can stop me if it's not clear. I can repeat it again. Any questions about it?
Sir, yes, sir.
Mr. Shruti Kirtan, suppose the seller comes into possession of the goods and the documents of title relating to a particular movable property and he intends to transmit it or transfer it to a purchaser for value, and then he does it himself or through an agent or through a broker. Then the person who is the purchaser comes into possession of the goods or documents of title. The purchaser who acts in good faith. Good faith means with all good intentions, he makes all inquiries, thinking that the seller has got title to the property as well as to the documents of title. The purchaser acquires a good title, though the seller's title may be defective. Is it clear to you, please? See, please remember, no person is a fool to hand over the documents of title, isn't it? When you want to sell your car through various shops nowadays, agencies are available. Online also you can sell. You can also go to the shop, hand over your car, and that person sells it for you. In other words, he is a person selling second-hand cars, then certified cars, as you may call it. Then he is in possession of the RC book. He is in possession of the insurance. He is in possession of the purchase bill. He is also in possession of the various documents like insurance, etc., etc. And then he wants to transmit it or transfer it to a purchaser for value. Then he does it himself or hands it over to a mercantile agent whose business is to whose business is to sell the cars or sell the cars to third parties. The third party who purchases the property, thinking that the seller has got rights over the property, however defective it may be, and the purchaser acts in good faith, makes all inquiries possible, and also is satisfied because the documents of title as well as the other documents concerning the particular movable property is being transferred to you, then irrespective of the defective title of the seller, the buyer acquires a better title provided he acts in good faith and without notice of any defective title of the seller. Is it clear to you, please? Mr. Shruti Nandan. Is it clear to you, please? Shruti Kirtan, sorry.
Yes, sir. Yes, sir. Yes, sir.
Now sir, I can't raise my voice beyond that, sir, because I modulate my voice. Here, sir, now we go to the conditions and warranties as prescribed under the Sale of Goods Act. The entire Sale of Goods Act is dependent upon this chapter. This chapter is the most important chapter which governs sales of movable property. Here, condition is defined as a main element of the contract and warranty is collateral to that condition. I put it this way, sir. What is a condition? Condition is the main element of the contract. For example, when you want to purchase a car, nowadays, new cars are coming into the market. I want to purchase a car which is the latest car. For example, I think so many cars are there. Only Maruti make, or let us say manufactured by Kia. Kia has come out with a car called Carens, which comprises of which contains seven. It's a seven-seater car, or it has got the modern facilities. You got the Bluetooth. You can sit in your car and talk. You need not lift your cell phone also. Your cell phone is connected to the display board, and on the display board itself you can talk to someone without being caught by the police, because it's an offense talking on cell phone when sitting in the car or driving a car or going on a scooter. Or it contains Euro 5 regulations, or Euro 5 it conforms with Euro 5 requirements, or let us say it has got tires which are from a good company. The engine also is duly certified. It is in a fit and a proper condition, and it is of a particular model and a particular make. And that is the essential condition, because it goes at the root of the matter. Why, sir? I want to buy only Kia car, or I want to buy only Maruti. That person cannot say, sir, Kia is better than Maruti, sir. You buy Kia. He cannot compel me to buy any car which I don't want. I specify the model, I specify the make. I also try to verify what are the facilities that are available, accessories which are provided as far as the car is concerned. It goes at the root of the matter, and then it is called a condition. Are you able to understand, please? Any stipulation which is incorporated in a contract, which goes at the root of the matter and which is an essential part of the contract, it is called a condition. Am I making myself clear to you, please? Then, along with that, you get certain facilities. For example, nowadays, please remember, it's a cutthroat competition which is going on in the market. Every person tries to push his product. What the car dealer tells you is, sir, suppose you buy a Kia car, we will give you 5 years warranty that we will attend to all the repairs, and in case of any defect, manufacturing defect, we will also replace it. And in case of any defective part, we will replace the part. Or if possible, if the car is gone beyond repair, we will also give you a new car for that. This is an assurance given to you. This is called a warranty. And sometimes some dealers go to the extreme extent of saying, we will also pay you your comprehensive insurance for that particular year. And for the 5 years contract, we will repair your car free of cost. Of course, other incidental charges like oil charges and all will have to be paid by you. When such rosy promises are given to you, naturally anyone will fall a prey to it, isn't it? Naturally, you don't go alone. You take your wife also along with you. Your wife is fond of some colors. God knows for what purpose. A day was there when black was supposed to be inauspicious. But if you see most of the cars in the market today, they are a black color. Or I still remember Maruti 800 when it had come into the market. Red color was supposed to be a fancy. Whenever you want to buy a Maruti car, and that too in red color, it used to cost you 5,000 rupees more because to give you that car. And I think they tell you also that all the RTA work, like getting the number for your vehicle, or getting the insurance paid for your vehicle, or when trying to make it roadworthy, or trying to make some alterations, or trying to make some renovations, and also try to fit it with some accessories. Everything will be done free of cost. This is a warranty, isn't it? But what is a condition, sir? A condition is one where it goes at the root of the matter and is the essence of the contract. Where I say, sir, today we are in 2024. I want a car of a particular specification of 2024 model. He cannot say, I will give you a 2022 model, but I'll charge the same thing. See, I can repudiate the contract, I can avoid the contract and say, I'm not interested to buy a 2022 car, I want only 2024 car. Then he also says, sir, the car is not readily available, it has to come from the factory. I shall deliver you the car as and when it arrives in my shop, and also intimate you. What have you contracted for? You are contracted for a 2024 vehicle, and that to Kia or Maruti, whatever you may call it, of a particular brand or a particular make with Euro specifications and with accessories and also other facilities. and which goes at the root of the matter, where the contract goes at the root of the matter, it is called a condition. Yes.
Sir. You got it.
Then what is a warranty? Warranty is one where the added facilities are given to you, where there is a specification that the car which is sold to you is conforms with all the Euro regulations, and also it is fitted with the parts which you have contracted for, and it corresponds to a particular model, and we undertake to deliver the car after servicing and after fitting all the parts. Then in that case, I need not accept the goods till such time it conforms to the contract. But any other additional benefit that is given to you by repairing the car, replacing the parts, replacing the defective parts, and also attending to some parts which have got worn out, and the accessories which are defective, or the tires which are given to you are not of good quality, then in that particular case, it is called a warranty. Are you able to understand, please? Condition is supposed to be an essential element of the contract. But as far as a warranty is concerned, warranty is collateral to the condition. What is a warranty? Warranty is I will give you free servicing for 3 years, three services. Number one. Number two, I'll replace the defective parts or I'll repair the defective parts. In case of any mechanical trouble, I shall repair the car. I shall give it to you in a worthy condition. And fourth one is we will also pay you the insurance for 5 years. Of course, no one gives you for 5 years. We will pay the comprehensive insurance for that particular year when the car is delivered to you. All these facilities are given to you. These are called warranties. I think you know when you're all salaried people, some of you are salaried people, you get the salary. Along with the salaries, you get the perquisites also. The car is given to you by the company. A chauffeur is also given to you by the company. The chauffeur is paid by your company, and you are given a house on lease free of rent, or you are given a housing accommodation, you are given furniture, or you are given a television set, or you are given a net connection, or you have got a Wi-Fi connection, so on and so forth, which is in addition to the property which is sold to you. They are called, salary which you get, sorry. They are called perquisites. Perquisites is any additional benefits which you get in addition to the salary is called perquisites. Or every 3 years, we will give you LTC also, leave travel concession. That means yourself, your wife, and your children will be given free air travel or free train travel. All these things are supposed to be perquisites in addition to your salary. In the same way, as far as the condition is concerned, condition is supposed to be a main element which goes at the root of the matter, and it has to be strictly complied with. It is called a condition. Warranty is any additional benefits which are given to you, irrespective of the sale, irrespective of the sale, it is called a warranty. Is it clear to you, please? And condition is the primary element as far as the contract is concerned. As far as warranty is concerned, it is collateral to the main condition. Then, what are the distinctions between condition and warranty? Condition is supposed to be an essential part of the contract. Condition is supposed to be an essential part of the contract, and the breach or violation thereof gives rise to repudiation. Repudiation means retract, refuse, or avoid. Repudiation of the contract or claiming damages also. Are you able to understand, please? A breach of a condition, a violation of a condition which is primary, or a condition which is essential element of a contract, when violated or breached, the buyer gets the right of repudiation. That means avoiding the contract, or in addition to it, he can also claim damages for the breach which has been made. Are you able to understand, please? So, first distinction is a condition is supposed to be a main element of the contract, which goes at the root of the matter, and a breach thereof gives rise to repudiation, avoidance by the buyer, and also in addition to claiming damages. Am I making myself clear to you, please? A breach of a condition gives rise to an action where the buyer can repudiate, avoid, resign, and also claim damages. But as far as a breach of warranty is concerned, since it's collateral, it is said you cannot repudiate the contract, you cannot avoid the contract, you cannot retract the contract. But what all you can claim is damages alone can be claimed. Is it clear to please? So, breach of a condition gives rise to an action for repudiation, avoidance by the purchaser, in addition to claiming damages. But as far as a breach of warranty is concerned, you cannot avoid the contract, but you can only claim damages. Are you able to understand this distinction, please? A breach of a condition gives rise to repudiation or claiming damages also. But as far as breach of a warranty is concerned, it gives rise to only damages and you cannot avoid the contract. That's the first distinction. The second distinction is uh, that is next one is second one is, for example, if a second-hand car is sold with a warranty that it is fit for a particular purpose and avoided, and it turns otherwise, the contract cannot be repudiated and only damages shall be claimed. Suppose a second-hand car is sold with a warranty that it is a particular make and model, and it turns otherwise. See, normally, when you buy a second-hand car, the person who sells the car will try to get rid of the car as far as possible. He says, "Sir, आप जो खरीद रहे हैं, ये सोना है. ये गाड़ी लिए तो आप पूरे लोग वहाँ चौकेंगे और बोलेंगे आप नवाब साहब है." And he also says it can run at 150 kilometers per hour. And he also says the tires will last you for nearly 3 years, and 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 it is a hassle-free car. Please remember, unless he tells that, no one will purchase it here. But these are all warranties. It's not a condition. See, after all, you want to buy a car of a particular make, of a particular model. But in addition to it, the person who sells it, a second-hand car I'm talking about, he says, "Sir, this car is a Lakshmi car. If you purchase it, it'll just speed. It will give you 150 kilometers per hour, and it can pass through any road, any lane, any by lane also. And if you go in that car, you can have a pleasure trip." But this is all a warranty. He said, after all, purchasing a car of a particular model, it's always settled. But the other promises which he gives you is a good car. It contains good tires. I can also vouchsafe regarding its fitness. I can also say that's a good quality, and I can also say that I can repair the car in case of any defect. All these things are promises which are held out by the seller to a purchaser. They are all called warranties. It does not go at the root of the matter. What is at the root of the matter? Whether the car of a particular make, of a particular model, is agreed to be sold to you. That's all. But if some other car is delivered to you, which is not of that make, which is not of that model, or which does not contain anything, then in that case, it's a breach of a condition. But other additional promises that are given to you is, let us say, the car will be repaired, car will be serviced, car will be attended to, any defective parts will be replaced. We will repair the car, and and it is roadworthy. It can run at 150 kilometers per hour, and it will not skid under any circumstances. It contains airbags. Airbags will open in the case of mishaps, and it contains a free ignition, and it contains all the facilities. All these things are rosy promises that are made to you. They are not main elements of the contract. They are all collateral to the main contract. The additional facilities that are given to you are collateral to the main contract. They are called warranties. You cannot avoid the contract, but you can only claim damages. Is this clear to you, please? This is a second distinction, please. As far as the breach of condition is concerned, it gives rise to repudiation of the contract, avoidance of the contract, and damages. But As far as warranty is concerned, it is collateral to the main idea, and breach of a warranty gives rise to an action only for damages and not for repudiation. Am I making myself clear to you, please? If you want me to slow down, I'll slow down. Again, I'm repeating it. A breach of a condition, which is basically goes at the root of the matter or an essential part of the contract, gives rise to a repudiation or avoidance of the contract and also claim damages. But as far as the breach of warranty is concerned, the additional promises that are made, additional benefits that are given to you, in case of any violation, you cannot avoid the contract, but you can claim damages. Is this clear to you, please? Any doubts? I'm repeating it the fourth time. The next one is, if a horse is sold for use and a warranty is given that it can run 50 kilometers per hour but runs only 30 kilometers per hour, it is a breach of warranty and damages can be claimed. See, remember, people develop love for different objects at some place or the other. Suppose, let us say, a horse dealer says, sir, my horse is the best horse. It will run at 50 kilometers per hour. It will go more faster than a motor car, and it gives you that warranty. But as far as sale is concerned, there's no problem at all. He says the condition is it's a good horse. That's all. But he also says the horse can run at 50 kilometers per hour. But when you use it, it runs at 30 kilometers per hour. Then is it a breach of a condition or breach of a warranty, please? Can you tell me whether it's a breach of a condition or breach of a warranty? It is a breach of a warranty because they are all additional promises that are given to you so that that particular commodity can be sold. For example, here there is if an oil, suppose an oil is sold stating that it's a refined oil and some other oil is mixed in it, a breach of condition and can be repudiated. So suppose I order for super refined oil, then let us say some make either fortune or natural or whatever it is, but it is mixed. What I've asked for you, sir, I have asked for a good quality oil, a refined oil which I use for cooking. I asked for a particular make. I have asked for a particular specification, and they are at the root of the matter. And you have to supply it to me without any difficulty that super refined oil. But instead of supplying the super refined oil, you mix it with some other oil and you take delivery of it, then in that case, it is only a warranty. Why? Because it does not go at the root of the matter. No doubt what is delivered to you is refined oil. But what is mixed in it, of course, you can claim damages by saying you have not given to me the actual quality which you have promised. You say it's a super refined oil. It is not super refined oil, but it is something mixed with that. Then the question is, you cannot avoid the contract because when he says it's a super refined oil, it means it's a promise that is given to which is in the form of a warranty. Warranty, a contract cannot be avoided, but only damages can be claimed. Then normally when goods are sold on assurance given that the pre-insurance will be paid and free service for 5 years, it is a warranty. I told you also, sir. Now most of the people who are giving you the cars or selling the cars are giving you various facilities or various shops. They say that it is a free insurance. That means the insurance for that year will be paid by the company who sells the goods, sells the motor car to you, and also says free service will be given to you for a period of 1 year. Let us say no one gives you for 1 year, but let us say 1 year. It is a warranty which is given to you because car is sold of a particular make, of a particular model, of a particular name. That is the main condition. That is sold to you. But additionally, some promises are made. We will provide you free service. We will provide you free replacement. We will provide you free repairs. We will give you servicing for 5 years. We will also pay the insurance for that particular year and also attend to the RTA work. You are getting a number for your car, so on and so forth. They are all supposed to be warranty. In case it's a warranty, it is not a main element of the contract. You cannot repudiate the contract, you cannot avoid the contract, but you can claim damages for breach. Suppose, let us say, uh, Here, suppose let us say they sell a car to you. Please remember, they will not sell the car to you without servicing it. They say that we will sell the car to you, and before delivery, we'll do the servicing free of cost, giving and give the car to you in a deliverable condition. Can you say giving the car after servicing, is it a warranty or is it a condition? Selling the car is a condition, in a good condition, in a good model, or a particular specification. But the additional promise that is given to you, which is collateral to the main contract, it is called a warranty. Suppose they say we will give you the car after servicing, that is a warranty. And if the company violates it, you can only claim damages, but you cannot avoid the contract. Are you able to understand this? The distinction between condition and warranty. And let us take another example, sir. Uh, uh, Suppose, let us say, a reputed opera singer or what is called reality shows which take place. They say the reality show will take place only after rehearsals and rehearsals. Then, in that case, it is said that suppose, let us say, the person who is a singer or undertakes to perform the show for 3 weeks, let us say, it's a contract. But before the contract is to be performed, she suffers from a severe illness where she is unable to move from her bed, where she is unable to even open her mouth. Her voice is also not clear. She cannot perform the contract because of those supervening difficulties. Then, in that case, it can be treated only as a breach of warranty, but not a breach of condition. Condition is she's prepared to do it. She's prepared to perform. But the supervening, another stipulation that was incorporated is that she shall perform for 3 weeks. And unfortunately, because of the supervening impossibility, she being affected with illness, she cannot perform. Only damages lie, but the contract cannot be avoided. Or let us say the performance can be done only after rehearsals. Rehearsals bole to, that is before the show is run, 3 or 4 rehearsals are held. A pre-show is arranged, and in that you must try to pass, and then alone you can perform it. Then let us say on the day, suppose rehearsals you don't do it because of your illness, it cannot be said that there is a breach of condition. At the most, it can only be a breach of warranty, and you are liable only for damages and not for repudiation of the contract. Here, sir, what is the advantage of warranty? Warranty. Please remember, unless warranty is given, sir, none of us will purchase anything. Why, sir? Because we are given some additional facilities for acquiring a particular product. And please remember, I told you also, whenever you purchase a product, whenever you purchase a article, try to insist on the bill. Because in the bill, you'll have TNC. What is TNC, sir? Terms and conditions. For how much time the warranty has been given to you. Warranty has been given to you regarding the fitness and regarding the quality of the product, and also an undertaking that it has undergone quality tests and it has gone through the quality control mechanism, and that is fit for consumption or fit for being used, so on and so forth. All these things in the orally don't depend on oral submission, sir. Try to insist on the bill so that the bill will contain all those things. When you preserve that bill, it is prima facie proof that you have purchased it from a particular shop on certain conditions and certain warranties. And that's the reason when you purchase a new product, a warranty card also is given to you. That is for 5 years or 3 years or whatever it may be. That is, in case of any difficulty, you can definitely phone them up. They will attend to it and they will do it free of cost. Or if they don't do it, then you can hold them liable for damages and not for repudiation. Is it clear to you, please? Here, suppose let us say here whether a particular stipulation is a condition or warranty depends on facts and circumstances of each case. Suppose let us say a ship is ship a warranty is given regarding its seaworthiness, a condition of in condition of engine trouble, no termination. Here, please remember, no person will try to take you in a ship which is defective. He says my ship is the best ship. He has no problems at all. But sometimes what happens is because of acts of God or acts which go beyond your control, certain problems arise. Does it mean that the contract can be repudiated? No. At the most, that promise of seaworthiness can be treated only as a warranty because a stipulation given regarding the worthiness of the ship, and you can only claim damages, but you cannot avoid the contract. Then warranties would be a condition in the same contract. A promise that it will be serviced before delivery would be a warranty. Please remember the company also says, sir, before delivery, no doubt you agree on the car, you agree on the model, agree on the make, agree on the color, agree on the shape of the vehicle, and agree on the parts which are there in the vehicle. You also test the engine, you also have a test drive, you also have everything. You are satisfied with that. But along with that, they give you a promise that they will give you a free car insurance. They'll also arrange for fitting extra parts free of cost, or they'll also give you certain other facilities or free servicing for 3 years, three times or 5 times, and for the 5 years period when the warranty exists, they shall service your cars, so on and so forth. These are all promises which are held, which are relateral to the main contract. No doubt, you cannot return the car, but you can definitely insist on breach of warranties and claim damages. A breach of a condition gives rise to an action for repudiation by the buyer and also damages. But a breach of a warranty gives rise to only damages, and repudiation is not possible. Here, one funny illustration is given, sir. Here it is said, a car dealer pointing at a particular vehicle says that the car will suit you and has a mileage of 50 kilometers per liter. This amounts to a breach as the seller made the stipulation which forms the essence of the contract. See, nowadays when the petrol, diesel, and all the rates have gone up, everyone would try to take a vehicle which gives you the petrol efficiency and less money to be spent from your pocket. The seller, without keeping quiet, it says, this car is more suitable to you. It adds to your personality. You look like Amitabh Bachchan. You become a celebrity. And then anyone seeing you on the road will see that Amitabh Bachchan, duplicate Amitabh Bachchan is going on the road. And they, all of them will salute you. And you'll get all respect from the road or the road users. And everyone will look at you and get surprised at your car, and they'll admire your car like admiring a beautiful girl. Naturally, sir, when the question of girl comes, anyone will be tempted. अच्छी बच्ची मिले तो कौन चुप बैठेगा भाई? Everyone is human being. The question is, a beautiful girl, it look like Aishwarya Rai or it look like Madhuri Dixit. Naturally we go for that car. Or let us say sometimes what they do is they fix the photo of Maruti Dixit as far as purchasing that particular car is concerned. And if you are a lady, you feel that you are going to be next Madhuri Dixit, or you are going to be the next Aishwarya Rai. We don't become Aishwarya Rai, we don't become Madhuri Dixit. We are what we are. But we are tempted by that. But if it's an essential part of the contract and you go on that particular promise and the contract cannot be performed without that particular promise, it's a condition. But if it is only given to you as an assurance, then it's a warranty where you cannot repudiate the contract, but you can definitely claim damages. Then here, suppose it's a conditional contract where it is said a specific event, the occurrence of which is uncertain, conditional upon the buyer getting planning permission. Suppose, let us say, I am a car dealer. I want to get my daughter married. Then naturally, sir, when I think getting daughters married is a big task today. and tell the bridegroom, sir, I will try to give you this car provided without any consideration, but you must get the necessary permissions under the relevant laws. Here it is said it's a conditional contract, that is subject to the condition, an uncertain event which is going to happen or does not happen, then the question of repudiation or otherwise doesn't arise. Then response of the parties involved, they are set out in the contract. For example, when you buy a car from a particular car dealer, a new car I'm talking about, and there is a warranty given to you that the parts will be replaced, parts will be repaired, new parts will be inserted, or the car will be attended to by the dealer himself, and under no circumstances you shall give the car to a private mechanic to do the needful. Once you go to a private mechanic and get the repairs done, it goes from bad to worse. The seller is not bound by the warranties. Are you able to understand, please? There is some stipulation also, sir. For example, some prime cars like Skoda. Skoda cannot be repaired by a private mechanic. It has to be done through the computer. And from the computer itself, they repair the vehicle. Suppose in breach of that, you hand it over to a private mechanic for repair. Please remember, don't think that the other side is a fool. He knows everything. He knows where. Sir, have you given the vehicle to some private fellow? He has touched it. That's the reason it has got spoiled. I am not going to be bound by the warranty that I have given to you. So certain conditions can be imposed for imposition of conditions and warranties. Then there are two kinds of conditions and warranties. One is called express and another is implied. What do you mean by express condition? Express condition is what is embodied or what is incorporated in writing or in a printed matter in a bill which is given to you. That is called express. Implied are not, which is not part of the contract, but law presumes their existence. What do you mean by that, sir? Express means anything in writing, anything in print, anything in a lithograph, anything in a caricature, anything which signifies that they are the conditions agreed upon. In anything that is put to writing, that is called express. What do you mean by implied, sir? Implied means which is not included in the contract, but law presumes their existence. Naturally, sir, though it is not incorporated in the contract, but still what happens is law presumes that the car which is sold to you is worthy, it corresponds to a particular model and a particular make, and the warranty is also given to you, which goes without saying. The free servicing also, which is given to you, goes without saying, and repairs also and replacement of the worn out parts is also implied without even being mentioned in the contract. All these things is they are called express and implied. Then example, right to sell, sale by description, sale by sample, sample and description. Sometimes what happens, sir, when you sit in the shop, the person who wants to sell the goods to you will not come directly to you. And especially if you go to the textile market, I think most of you know, when you go to the textile market, the person who is the owner of the shop, so many agents come to him and the agents show them the sample. When they show them the sample, they say, sir, this is the best sample, this is the make in which it is made, and also you can place orders for that so that they can arrange for delivery. And the sample is also given to you, one piece is given to you, and it is sale by sample. What are the express conditions, sir? Express conditions is the goods which are going to be delivered to you as a buyer should correspond to the sample of the same bulk and the same description and the same condition, same quality, so on and so forth, quality as well as quantity. And when it is also presumed, implied conditions is you cannot dispute the right of the seller. When the seller has got the possession of the goods, ownership over the goods, or the property is with him, it is presumed that he has got a right to sell. Then it is also sale by description. For example, suppose you want to buy kanchi sarees. Kanchi sarees, perhaps, or you say rice. I mean, why go for kanchi sarees? You go for rice. You got grade 1, grade 2, grade 3, grade 4 and all. As far as a dealer dealing with rice is concerned, he knows what is grade 1, what is grade 2, what is grade 3, what is grade 4. Then when an agent comes to book the goods, he takes the samples of every grade and he says, sir, I want only grade 1 rice, that is Sona Masuri, Sona Masuri of Karnool. I want about 100 quintals of rice of grade 1. Then it's a description that is given, bulk that is given, quantity that is given, quality that is given, grade that is given, the sample which is given, and according to the sample, the goods have to be delivered. The next one is sample and description. That is, sample is also shown to you, and the goods which are going to be delivered to you should correspond not only to the sample but also to the description. Are you able to follow, please? Sale by sample, as I say. When a sample is shown to you, quality is also shown to you. You also know grade 1, grade 2, grade 3, grade 4 because you're a person dealing with that. The delivery which has to be made by the seller to the purchaser, the essential condition is grade 1 rice has to be sold at a particular price and of a particular description, of a particular quantity, particular quality. And the sample will be retained by you, and you will be given a right of examination also whether the goods which are supplied to you corresponds to the quality, corresponds to the contracted one, and also corresponds to the quantity and description which has been contracted for. That is, strictly it has to be according to the sample. Is this clear to you, please? Even in cotton also, especially ready-made shirts. Ready-made shirts also, you've got different qualities. T-shirts, you've got different qualities. Open collar and closed collar, that is round collar. When I want only round collar, you cannot supply to me a T-shirt with ordinary collar. That is not the sample which is shown to me is the round collar. The goods which I have ordered is the round collar T-shirts. The quantity which I have ordered is a particular bulk, and the goods which I have offered is of a particular make. The supply or the delivery has to correspond to the sample as well as the quantity supplied. Are you able to understand, please? And here, a shoe manufacturer, example is, a shoe manufacturer sends a perfect shoe sample to the seller, to the purchaser seller, but at the time of delivery, it is a poor quality. Repudiation and damages can be claimed. Here, sir, that is, it is said, a shoe manufacturer, be any shoe, sir, Adidas or Reebok or whatever it is, he sends the best quality shoes to you, a sample is sent to you, and you are asked, it is sent to you for approval. You agree on that shoes of that particular quality, of that particular make, and of that particular variety which is used. But what happens is at the time of delivery, a poor quality shoes is supplied to you. Here, what are the rights of the purchaser, sir? Here's a breach of condition. What is the breach of condition, sir? A good shoe of a particular make, and according to the sample which is shown to you, the goods will have to be supplied of the same sample and the same quality and quantity. But instead of that, a poor quality product is sent to you. It gives a right to the purchaser to repudiate the contract. That is, he can return back the shoes, or he can say, I don't want to take delivery of the goods, and he can also claim damages for non-delivery of the perfect shoes which was sent by sample. Are you able to understand, please? Then, any doubts about it? Any doubts about it? Now we go to
Sir,
the...
one second.
Yes, sir.
Once again,
Mr. Sutikit.
implied contract.
Sir, suppose, I'll tell you, sir. Suppose a shoe, I'm giving you an example. A shoe manufacturer sends a perfect shoe sample to the seller, right? You are a seller selling those shoes. The person who manufactures those shoes sends you the best shoes, best quality shoes. But when he has to really deliver, he does not sell the same variety, same quality shoes, but he sends you an inferior one. You need not take delivery of the shoes. You can return it. You can avoid the contract and also claim damages. This because of a breach of condition. Am I making myself clear to you, Mr. Sutik Tirthan? What is your doubt you have expressed? The implied conditions, I think perhaps I recollect. Implied conditions is the goods which are supplied are of a good quality, they correspond to the sample, they are of good quantity, they correspond not only to the sample, the quality and the quantity and the bulk which is agreed upon. They are all the implied conditions as far as the contract of sale is concerned. Mr. Sutikirtan, am I making myself clear to you, please? Yes?
Okay, sir.
Not okay, sir. Please have a crystallized mind whether you are sure about it. I don't want to go further unless you are satisfied.
Yes, sir. Yes, sir.
Thank you. Next question, please.
Sir, what is the difference between guarantee and warranty, sir?
Not guarantee, condition. Condition. It's not guarantee. We don't come to the question of condition, guarantee here. We come to the question of condition and warranty. Condition is which is the main element which goes at the root of the matter or the crux of the contract is what is called a condition. Am I making myself clear to you, please? Suppose let us say you want to buy a motor car. I say, sir, I want latest car as far as Kia is concerned of 2024 model, which corresponds to Euro 5 regulations, which contains the best parts, good ignition, good engine, good tires, and all the other parts. And unless I get the same car, that particular description of the same model and the same color which we agree upon, it is called a condition. If it is not done, it is a breach of a condition because I have specified what I want. It's the main purpose of the contract, and a breach thereof gives rise to a purchaser to repudiate. Repudiate means avoid the contract, not to take delivery, and also claim damages for breach thereof. In other words, a breach of a condition, violation of a condition gives rise to repudiation, avoidance, and also damages. But as far as warranty is concerned, any promise that is given to you as an added assurance, like free service, free replacement, free repairs, and let us say some parts which have got worn out, you try to replace it, or you try to attend to any mechanical trouble or problems in the vehicle, or pay the free insurance for that particular year, and also get you the RTA number for your new vehicle, and also attend to other services. They are all promises which are held out to you for a particular period of time, that is 3 years or 5 years. For that 5 years period, those promises will continue. Am I making myself clear to Mrs. Gauzia, please?
Yes, sir.
Next.
Sir, please, sir, there is implied definition, sir. Implied condition definition, sir. Not example.
Implied condition means though they are not incorporated in the contract itself, law presumes certain conditions to exist. For example, worthiness of the vehicle, usage of the vehicle, utility of the vehicle, the parts that are inserted in the car are of proper condition, proper fitness, and the contract, and what is also called is a seller who is selling the particular product or a mobile property has got right to sell that property. They're all implied, though they are not incorporated in the contract. In other words, I put it that it goes without saying that they are presumed. Am I making myself clear to Mr. Shruti Kirtan, please?
Yes, sir. Okay, sir.
Next.
Sir, good evening.
Good evening.
This is Anu.
Yes, Anuradha Vakaraj. Yes, madam.
Sir, there seems to be a very thin and hairline.
Exactly. It's a thin. See, what you can say is the main purpose of the contract, main elements of the contract, stipulations of a contract, which goes at the root of the matter or essence of the contract is called a condition. But the other additional promises that are given to you in addition to the stipulations is called a warranty.
Yes, sir.
One is the main thing and another is collateral.
Yes, sir.
And
Sir,
the remedy for breach of a condition is repudiation and damages. Breach of a warranty, only damages, no repudiation.
Yes, sir. I understood it.
Thank you.
And regarding conditions, sir,
Pardon?
there is one thing out. Regarding conditions,
Yes.
when it comes to breach of condition,
Yes.
breach
Yeah.
of a good,
Yeah.
unless before taking the delivery, I will not be able to estimate whether the condition is kept up or not.
Then I take Then I take the assistance of an expert. Yes, I take the assistance of an expert who evaluates it, gives a report, forward it to the seller, and say these are the defects which goes at the root of the matter and the breach of condition.
Okay.
Right.
Sir, in spite of that, sometimes in electronic goods like
Yes.
TV or refrigerator,
Yes.
still there would be, in spite of their marking
No.
saying that this is all conditions are kept up.
Yes.
We get the goods home, and sometimes it has some fault.
Yes.
Again, it is detected that the conditions are not met with, and
Yes.
we find fault.
Yes, yes.
So will that be a breach of
It
condition?
will be,
or
it will be a breach of condition only because worthiness is guaranteed, which is at the root of the matter. Where there's a breach or violation, it's a breach of a condition, not warranty. But there, what you have to do is you must go to the same shop and ask for repairs or replacement to be done, not to a private fellow.
yes, exactly.
Right.
And sir, one more doubt.
Yes.
Can the brand of good
Yes.
be taken as implied condition?
Definitely. Because brand is, suppose I want Samsung. Only Samsung has to be delivered to me of a particular model for the particular year.
Okay. Thank you, sir.
Welcome.
Sir, good evening, sir.
Good evening.
Sir, may I ask a question on CPC, sir?
Sir, not any of, ask me, sir.
Sir, partition suit was filed in the court, sir.
Yes.
And in that suit, it's several corrections were made. And
Yes.
later, plaintiff need copy was filed, sir.
Right.
In that need copy, today they came for the summons, sir.
Right.
Went to the court for the defendant too.
Yes.
And after verifying those documents along with the need copy, sir,
Yes.
we found that
Mhm.
plaintiff did not signature in the entire need copy.
Right.
It was only signed by the advocate.
Right.
Is it allowed, sir?
Need copy need not be signed by the parties, sir. Need copy can be signed by the advocate also. There's no problem at all about it.
Okay. Thank you, sir.
Welcome. Any more questions, please?
Sir, good evening, sir.
Good evening.
A clarification is, so who is the person or who is the deciding person who will decide whether it is a breach of a condition or a breach of a warranty?
Breach of condition or breach of warranty depends upon the contract. And in case you repudiate the contract and our claim damages, it's the court which has to decide. And for that, it's better that you get it examined, the product which you are taking delivery of or about to take delivery, get it verified and take a report from an expert on that particular product. And then that will help you to show that's an inferior variety that has been delivered to you or you want it to be delivered. Then that will help you to show that you can avoid the contract and also claim damages, isn't it? Right? Or you take the case of a sample, sir. If you sale by sample, you can say that the quantity that is the product which is going to be delivered to you does not correspond to the quality, does not correspond to the sample, does not correspond to the description, does not correspond to the fitness, does not correspond to the worthiness, so on and so forth. And that's the reason we take the opinion of an expert in that particular field. I'm making clear, Mr. Prasadara.
Yes, sir. Thank you, sir.
Next, sir.
Sir, cases related to goods and services, this will be in consumer forum, sir.
Exactly, sir. But in consumer forum, what you have to satisfy is there is a relationship of a consumer and a provider of services or a person who delivers the goods. Then alone, Consumer Act applies. That condition is the first condition that has to be satisfied. Deficiency of service, inferior service, so on and so forth. They're all within the Vinyogadarla Chattam. That is what is called the Consumer Act. Civil, you cannot go to a civil court. Yes.
Any more questions?
Sir, what if it is travel industry where the service is, the goods is not physical one, right?
Yeah,
It's a service based.
So if it is by carrier, if it is by transport, or the buyer says, I will not take delivery of the goods unless I'm given an opportunity of examining the goods. That is at the time when the contract is made, No examination was given. Definitely, you can ask for examination, verifying the goods, bulk, quality, quantity, or the sample whether it corresponds to it. Unless that opportunity is given, the question of contract cannot be fulfilled.
No, sir. I mean to say in travel industry.
Yeah.
Suppose say if you go to a travel agent for any packages.
Yes.
Right.
Right.
So they commit one thing in their whatever the service. After doing that, they kind of commit. Add extra charges or the service is something bad experience that we had.
Yeah, for that you can make them liable in the consumer court that they violated the conditions of travel, isn't it? That's the reason you take a bill and show the particular clause to say that these are the conditions which I've agreed, and that I've agreed to travel according to their conditions. So when the breach takes place or violation takes place, you are asked to pay something extra that is against the contracted policy. You can definitely repudiate the contract or claim damages for the breach of assurance that is given by them. You can
so what is the procedure of filing, sir? First, legal notice has to be served,
legal notice to be given, and then go to the consumer court. And you need not engage an advocate also. You yourself can list out your grievances. The consumer court will decide the matter, and damages will be awarded or compensation will be awarded. This has happened regarding what you say is absolutely right. It has happened regarding Indigo. It has happened regarding Air India. It has happened regarding various airlines where they have breached the conditions. For example, they give you certain facilities which they don't give. Then, suppose the flight is delayed, they promise to give you free lunch or free dinner, which they don't give. Then you can make them definitely liable. They are incorporated in your bill itself. Breach of conditions. Sir. Right, sir? Any more questions, please?
So one more question, sir.
Yes.
So we have learned about service and goods, supply of service and supply of goods. Another typical example, suppose there is a student pursuing law from a particular university.
Yes.
But the person has given all the exams, the student has given all the exams,
right,
and he has done very well.
Yes.
But at the university level, there is some goof off. They could not correct the papers, or the papers got lost, or something happened.
Right.
They are not able to declare the candidate as passed.
Right.
So under which jurisdiction this comes?
You will have to go by writ jurisdiction only, sir. Under Article 226 of the Constitution. A writ lies against the university.
Writ petition.
Yes, sir. That is faster and quicker also.
Okay. So for that procedure, first we have to issue the legal notice.
Not necessary for a writ petition, no notice. If you want to issue, it will be an added feather in your cap.
Okay.
Any more questions, please? Mr. Leela Krishna. Leela Krishna, advocate.
Sir, good evening.
How are you, sir? Keeping good health?
Yes, sir. Very good and fit. Thank you. And very nice session is going on since so far, and very glad to be part of this.
Thank you. Thank you very much. I'm obliged.
Thank you. Thank you.
One announcement I would like to make here is that people from Prakasham district, people from people from Pitapuram and other places have also joined us. They are going to be our colleagues. But as far as my subject is concerned, my assurance to them is to repeat the Sale of Goods Act only after we finish it, because I don't want to stop it midway. And please remember, in the Sale of Goods Act, the biggest chapter of the entire Sale of Goods Act is only about conditions and warranties. And in Transfer of Property Act, you know, the law of mortgages. After this, after finishing Sale of Goods, I'll be taking up the Partnership Act, or I'll take up Negotiable Instruments Act, only the important provisions of Negotiable Instruments Act, like Section 4, then Section 118, then Section 138, 139, 142, 143, 144, 145, 146, 147. But please remember, when we conduct cases on the negotiable instrument side, of course, as far as my office is concerned, I don't conduct any cases on negotiable instruments. I only hand over the matter to my colleagues and give them instructions as to how to do. You've got a lot of defenses under the NI Act, but most of us forget. to use those defenses. For example, you got defenses like material alteration, change of ink, change of date, change of the drawer, then also contradictions in the complaint as well as in the bank memo, so on and so forth. These are all the defenses which are available to you. So one thing is this: after finishing Sale of Goods Act, my colleague tells me, the admin says that there are various groups which are joining. I will repeat this Sale of Goods Act again for the benefit of those who have joined recently. Thank you. Any more questions?
Sir, we are from Tirupati district, sir. Tirupati district also 4 or 5 members are joining.
Yes.
సార్ కేతన్ గారు, తిరుపతి బార్ అసోసియేషన్ లో కూడా మీరు మీ వాళ్ళు ఉన్నారు, కొంతమంది నా ఆప్తులే ఉన్నారు
సార్.
మా తాలూకు వాళ్ళే చాలా మంది ఉన్నారు. మీరు ఇప్పుడు ఏ జిల్లాలో ఎవరెవరు ఉన్నారు నాకు తెలియదు, కానీ జిల్లాకు ఒక మనిషి ఉన్నారు నాకు. మేము కూడా ప్లాన్ చేసినది ఏంటంటే వర్చువల్ క్లాసెస్ కాకుండా సార్ వచ్చి ఒక లెక్చర్ తీసుకుంటారు, ప్రతి సిటీకి వచ్చి తీసుకునే ఏర్పాట్లు చేస్తున్నాం. కానీ ఆయన ఏజ్ క్రైటీరియా మూలాన ఆయన 76 ఏళ్ళు పొద్దు నుంచి సాయంత్రం కూర్చుని అయినా సరే క్లాస్ చెప్పడానికి ఆయన రెడీగా ఉన్నాడు. కాకపోతే మనం ఆయనతో పాటు మేము వ్యవహరిస్తే నేను చేయగలను. మీ తిరుపతి బార్ అసోసియేషన్ వాళ్ళతో మాట్లాడండి, ఒక సెమినార్ లాంటిది అట్ టైం ఒక వర్క్ షాప్ లాంటిది మీరు చేస్తానంటే నేనే ఫస్ట్ పర్సనాలిటీ. ఆయనకి కొడుకునవనండి, జూనియర్ అనుకోండి, వెల్ విష్ అనుకోండి, అన్ని నేనే ఆయనకి. ప్రతి విషయంలోనే నేను ఉంటాను. మీరు మీ అసోసియేషన్ వాళ్ళతో మాట్లాడండి. ప్లీజ్ టేక్ మై నెంబర్. యూ హ్యావ్ మై నెంబర్ సార్.
Sir, once you can share in the...
I am Srinivas Kalyan.
Sir.
Please take my number, sir. నెంబర్ పెట్టండి చూడండి సార్ ఒకసారి చాట్ బాక్స్ లో. సార్ మీరు గ్రూప్ లో ఉన్నారా సార్? కేతన్ సార్. నా గ్రూప్ లో ఉన్నారా? ధర్మ లీగల్ లో ఉన్నారా మీరు?
Yes sir, in this group I am. Yes.
You can see my number in the same way. నాదొకటి ఇంకొక రెండో నెంబర్ అడ్మిన్స్ ఉన్నారు. 8157 is my number. అండ్ చాట్ బాక్స్ లో కూడా పెట్టాను చూడండి. You call me, I'll talk to you, sir.
Okay sir.
Thank you. We are winding up as of now. We'll see you tomorrow again.
Thank you, sir.
Thank you much.
Thank you.